I really do appreciate you coming to talk because we've been getting a lot of questions about the recent hearing on the Robert Robertson case.
Yes.
And for those that don't know who that is and maybe hasn't been following, I'm going to do just a very quick sort of timeline, just to get people up to speed, and then we can kind of talk a little bit about that. So, Robert Robertson was convicted of murder of his child, little girl.
Yes.
Back in 2003, I believe.
Correct.
And was sentenced to death.
Correct.
2009, he was sentenced under the shaken baby syndrome cause of action that they are criminal action back then.
Yes.
So in 2009, the American Academy of Pediatrics then pulls back on that shaken baby syndrome. It's not necessarily, they just, I think, I remember reading, I think that they just said there wasn't the kind of evidence needed to call it shaken baby syndrome, that there was more to it. It's very complicated, but more to it. Then in 2013, the legislature, which you were probably here for that, when it passed the legislation to allow the people that are sitting on death row to appeal their case to the Criminal Court of Appeals if there was new evidence and so forth.
It wasn't limited to death row.
It wasn't limited to death row.
It was if you were convicted of an offense under science that has later been debunked or changed, then you were afforded an avenue to appeal that to the Court of Appeals.
Okay.
And so that there were approximately 75 cases that were appealed in a 10-year period from 2013 to 2023. And some of those were death row, but some of them were other lesser, I don't want to say lesser crimes, but certainly crimes that did not have a death penalty associated.
They may not be sitting on death row, but
correct.
they were in prison and serving time for.
That's correct.
Okay. So as I understand it, Robertson did appeal to the Criminal Court of Appeals and was denied. And was it 2 Fridays ago? I believe it was 2 Fridays ago at 6 p.m. he was set to be put to death. And this is when really, I think, like everybody else, I didn't really know what was going on. You don't really hear about it until, say, there's a stay by the governor or something like that.
Correct.
But the Committee on Criminal Jurisprudence calls a hearing, and please stop me if I'm just. We showed up to the hearing, but we could barely get into the room. But we did actually go to the hearing. But and originally he was supposed to be there to testify, and that was at least that was the attempt to try to get him to come there to testify. So the hearing is about his case, and I think where people really need to kind of understand is this: there's there's two stories here. There's the shaken baby syndrome issue related to his case that a lot of defense attorneys and other people are trying to fight and tried to help, and his case happens to be one of those. And then there's the what's become called the separation of powers issue, where the legislature has, for lack of a better term, intervened. Right? I mean, that the right term, intervened or tried to intervene, or at least
exercise some of our powers established under the Constitution.
Okay. If you don't mind, I think this would be great for the listeners and viewers to understand a little bit about the whole separation of powers. I had this conversation with someone the other day, and they asking me what that meant, and I think it's really important.
Well, clearly our Constitution set up, and it was envisioned to have a separation of powers where you have a legislative branch that determines what the laws are and what the penalties are for breaking those laws. And then you have an executive branch that Attorney General's office, Governor's office, that sort of thing, that kind of oversees the process. And you have a judicial branch that looks at those laws and determines if the appropriate law was followed in connection with that specific case. And so under our Constitution, the governor, of course, has the right of clemency, and he is very guarded on that, and he should be. That is his power. And the legislature does not, we don't pretend to give clemency in this case. We simply, our purpose when we had a hearing was to see whether or not the 2013 law was being followed. It was critically important that...
That's an important point.
It is. This is exactly... let me go back or digress a little bit.
Sure.
There were a group of legislators, 80-something, that signed a letter weeks ago asking for clemency for Robertson, or a new case.
Okay.
A new trial. I did not sign that. I did not know enough enough facts about the case to warrant my involvement in that, and so I did not sign that. There are 86, I believe, or somewhat number of people, of legislators who did sign that letter. I wasn't one of them. But then, lo and behold, I'm on the Criminal Jurisprudence Committee, and the chairman of the committee wanted the committee to determine whether or not this case was impacted by the 2013 law that we passed that gave the Court of Criminal Appeals the right to review cases in which the scientific knowledge has changed over the years. And there's a little small nuance added to that. In 2015, we passed another law that said, again, where you have an expert that testified in the first trial and has now changed his testimony based upon scientific understanding that he now knows that he didn't know back then that's another grounds for the Court of Appeals.
Does that apply in this case too?
It does apply in this case. And so from the legislature standpoint, we spent this fall looking at bills that we passed in the last session and previous sessions to determine the effectiveness of those bills. That's what we do. We have interim hearings to determine the laws that we passed, how effective are they, and did they address the problems that we were trying to address? And this is no different. So the Criminal Jurisprudence Committee said, let's take a look at this case to see if our 2013 and 2015 laws are actually being followed by the Court of Appeals. Are they just giving it lip service? Are they really looking at the intent of the legislature and following the original intent of the legislature and applying our laws to this case? And that's what the case was about. So I began the hearing, and again, as a lawyer, I try to keep an open mind until I hear what the facts are and the evidence is. And that's exactly what we did for 2 days. We listened to almost 22 hours of testimony with regard to this case.
And if people don't know this, I mean, this brought out a lot of you had Dr. Phil there, you had John Grisham, the writer there, you had the exposure that this case had. I was surprised by, because when we showed up and we were just trying to get in to film the hearing, I had no idea Dr. Phil was on the list. And I was like, okay, this is a pretty big deal. And I thought everybody was there to shoot a picture of, Roberson coming up. No, they were waiting for Dr. Phil. But anyway, go ahead. I'm sorry.
That's right.
Yeah.
But that's what we were designed to do as a body, as a committee of the Texas House. We are authorized to look and instructed to look at the effect of the bills that we passed. And so this was the case to do that. I, for one, and I think I had an opening statement before the committee, or as we were beginning, to say we're not here to decide guilt or innocence. That was true then, it's true today. That committee is not deciding guilt or innocence. We're there to look at this case and look at the law that we passed and see if the if the ideals and the purpose behind the law that we passed are being followed by the Court of Appeals. Are they simply ignoring our direction? Because we've said this is an important avenue of appeal available to people who've been charged under a body of scientific knowledge that existed at the time of their charge, and has that body of scientific evidence and knowledge changed over a period of time that requires another look at the case? And do we have an expert who testified in the original trial that now believes his expert testimony was flawed because his understanding of the law, of the scientific knowledge back then, does not comport to what it does today? And so my understanding after listening to 20-something hours of testimony, that the shaken baby syndrome grew out of an effort to explain underlying body conditions, bleeding in the brain. There are three basic tenets associated with shaken baby syndrome that could not be explained by any other readily available explanation, if you will, other than shaking the baby, which we now know those body tenets, there are other explanations that now can be
in the case of this,
and other cases where you have a change in knowledge. The reason why shaken baby syndrome has now been debunked or discredited is because those underlying tenets or body conditions can be explained by other mechanism than shaking. They can be explained by pneumonia. They can be explained by, and I don't have all of them with me today, but the understanding of the scientific community has now evolved to where they can explain these body conditions other than by a physical shaking of a baby. Another problem with it, when you charge somebody with shaken baby syndrome, think about the name. What does the name say? Shaken baby syndrome. That implies to the jury and to everyone present that somebody shook that baby to get that condition. Well, who's the last person to have been in touch with that baby? Yeah. It was the father in this case. So the mere charging of an offense of shaken baby syndrome prejudices, in my opinion, the jury's view of the actions of the father prior to hearing any testimony. Just the mere charge of shaken baby syndrome would indicate to the jury that somebody shook a baby to death. Yeah. And the bodily conditions were a result of shaking. And so we want to take a look at that too. And we agree, and all the experts, we had multiple experts, scientific experts, pulmonologists from all over the country that said the body condition of that child, there are other explanations that would lead to that condition other than physical shaking. And so we as a committee thought that the Court of Appeals is not following the purpose of the legislature in passing that law. Yeah. They're not giving due consideration. And it is a small nuance, but from our standpoint, we think that the Court of Appeals is placing a higher standard, that the evidence must demonstrate that someone else, or there's another explanation, that you must demonstrate innocence in that analysis.
But it sounds like that's
for
not
example,
what
DNA.
DNA
right. is the biggest example of how science has changed over the years. Yeah. We now know that DNA is a body of evidence that is strongly based in scientific evidence. And so if you have DNA proof that the offender was not the one charged, then then they're exonerated. But the key difference is DNA points to another person that is guilty. Shaken baby syndrome, when you throw out that syndrome, it doesn't point to another person. And so we think, the committee thinks, that the Court of Appeals is putting another level of scrutiny on this change in scientific knowledge, to where that change in scientific knowledge must actually point to the innocence of the charge.
And that's not in the 2013 statute that was created. It doesn't. It does not allow for that interpretation.
We did not say you have to, by the changing in scientific evidence, you've got to demonstrate
also
innocence.
Prove they're innocent.
You got to, yeah. Okay. So we think that they're using that, and that's a valid purview of the legislature. That we're charged with responsibility of passing laws that make sense. If we're going to have a death penalty, then we need to make sure that people that are subjected to the death penalty by the state, that we get it right.
Yeah.
And so we've passed a law in 13, we passed another law in 15, defining it a little clearer in our opinion, but is it being followed today?
Yeah.
And so that was really the purpose of the hearing. It wasn't to prove guilt or innocence. It wasn't ultimately to do away, with his sentence. It was an effort to find out what the truth is, and how it's applied to Robertson's case. And that's why it was important for us to hear from Robertson. How did you? What was your perspective on the trial itself and the charge of shaken baby syndrome, and whether or not it's important for us to see his reaction to that?
Yeah, I listened to some. It was an interview with him. It's been a while. I think it was an older interview, and very difficult to kind of get from him what I would suspect that even if y'all were able to get him, it would have been difficult to discern what because he is he's got severe autism apparently. I'm just saying what I've read.
Well, it came out, and that wasn't known to the jury. I think, we can hear testimony from a lot of experts, pulmonologists who can explain things, but to me, the most powerful testimony was the juror, who was very articulate, very, very firm in her judgment, very firm in her analysis, that she said this was a shaken baby syndrome case. At every point in the trial, we were confronted with the fact that this was a shaken baby syndrome case.
Yeah.
And so they held up a teddy bear and they shook the teddy bear. This is what a shaken baby syndrome case is. And so for people that aren't connected with the case, who've done only if even a cursory review of the record, for them to say that this was not a shaken baby syndrome case is just they're ignoring the facts.
Well, there's a lot there. I started doing some reading, and there is a lot there. And of course, I haven't read the entire file, so I couldn't say one way or the other. I read General Paxton's, I don't know if it was his brief, but he did put out a statement, and he outlined a lot of things that he saw from the case. Again, like I said, I haven't read the files, so I'm just sort of repeating what I saw, and which is probably what most people are doing right now. And that's why we're here. It's like, what of all that is are the real things that we need to be thinking about? And I know that it seems like it caused this. Well, let me back up before I go there. So just to finish off, kind of after the hearing, then there was a subpoena to try and bring him to the committee, correct?
Yes.
Ultimately, who objected to it? Was it the governor or General Paxton? There's some. I think it was General Paxton?
I think it was
Is that
General
right?
Paxton.
Okay.
Yes.
So he objects to it. I believe that's correct. And if I'm wrong, then I apologize. But I believe he objects to it at the Supreme Court level. The Supreme Court agrees and says, no, essentially, you don't have jurisdiction, sort of. Basically, is what they're saying, right?
I think it went to the Court of Appeals and then on up to the Supreme
And
Court.
then on
and
up, that's
and
right.
the Supreme Court, I think, perhaps even issued an injunction, if you will. It's still pending before the Supreme Court as to whether or not
Yeah.
General Paxton has filed a brief and the House committee has filed a brief.
Okay.
And so it's still pending before the Supreme Court as to whether or not the House can
issue a subpoena. So then the county then does. I don't even know if you call it a stay. Well, whatever the county did is they did stay the execution. And
well, I think the warrant, the death warrant, is only good for 90 days.
Okay.
And it expired, like you mentioned before, at 6 o'clock on that day. So once it's expired, he is no longer under a death warrant, and the county or the district attorney there has to issue another death warrant.
That's something I didn't understand. That.
Yeah,
okay.
So the warrant that he was operating on and going to be executed under expired. The time expired.
At 6 p.m. that evening.
That's correct.
On Friday.
And so in order for the process it has to be restarted. And it has to be restarted by the district attorney.
Okay.
It has to request a death warrant, and then that process will be reinitiated.
And then it reinitiated.
Yeah.
So then it's fascinating. It's fascinating until I got into it. But so now there's sort of a hold until, and then now that there's got to be a resolution about this, and I think they're calling it the separation of powers issue,
Correct.
Which is the subpoena, I'm assuming.
Correct.
And once that's resolved, then things go back. I guess then the district attorney can decide whether or not he's going to move forward. Okay.
Correct.
Okay. So right now things are kind of on a hold until that happens.
That's correct.
And that's currently in process.
That's
okay.
correct.
So, I guess what I'm wondering is, what goes through my head is some of the other members on the committee, I think, were a little more aggressive about this than, and I think the way you laid it out is the way I've seen, oversight committees do stuff all the time. I guess some of the other members were a little more aggressive sending letters to the Court of Criminal Appeals, and that really set a storm off at the Capitol, at the executive branch, with General Paxton and with the governor. Where is that going? I mean, I know I guess I'm looking back, and the last election cycle was a pretty hard election cycle for a lot of people, and I know that I'm sure there's a lot of that still brewing about. Is this just leftover lingering from that, or is it?
I think it's there all the time. I mean, the inherent I don't want to say conflict, but the inherent relationship between the executive branch, the judicial branch, and the legislative branch has continued since we formed this state. So that's always there, and there's always a push-pull, whether it's a governor, for example, expanding his veto powers over the budget, line item vetoes. I mean, there's always a push-pull between the legislature passing bills and the governor's office, of course, having the right of veto, and that exists, and certainly. We all respect the judiciary and their role in this to determine guilt or innocence, but the judiciary is simply enforcing the laws that the legislature passes. So if their understanding of the motivation and the wording of the legislation that we pass if they're confused about that, then that is under the prerogative of the legislature. And we need to look at that and make sure there is no gray area, that there is no confusion, that they are following the intent of the legislation. And so, as we go through that process, the judiciary, I think, would welcome further illumination, if you will, as to what did you mean by that? We're confused.
Yeah.
So I would hope there would not be any conflict of roles or responsibility. I don't see this as a constitutional crisis at all.
Yeah.
I see this as simply the legislature trying to exercise its rights to see how the laws that we passed are being implemented and being judged by the judiciary. We did not attempt to violate the governor's clemency powers. He thinks, of course, otherwise, but we were simply trying to use all remedies available to the legislature and to this committee to find out the facts. Once Robertson was put to death, we would no longer have access to that testimony, and so that's why we acted with.
So that's the main reason it was sparked, is because once he's gone,
gone, it's gone.
It's not an issue anymore.
That's correct.
I mean, you could. This is not. I don't mean it to sound like a stupid question, but I mean it seems like if it does continue, and you do get another 90-day death warrant, and they do go through with his death sentence, I mean, it still seems like that's legitimately looking at that 2013, 2015 law is still something that would need to be done, because even if he's not there, I mean, he wouldn't have his testimony, personal testimony.
But we would have the experience that this case has demonstrated. Is there still confusion by the court on how you interpret that?
Mm-hmm.
We don't want any confusion, especially when you're talking about somebody's life.
Yeah.
If we're going to have the death penalty, and I, for one, support the death penalty for the right cases, for the right offenses. But we as a society cannot have a supreme penalty like the state putting somebody to death unless we get it right.
Well, I'll be honest with you. When I first saw it happening, I was very surprised. And in my career, of working at this capital and many other capitals for 30 years, it was the first time that I've actually seen. Now, I don't think it's unprecedented, but for me in my career, I'd never seen both Republicans and Democrats come together on a death penalty case. I've just never seen it, and I was very surprised, and it was very. Obviously, you could see from all the people that came to the hearing that it definitely woke a lot of people up. Do you think that is it the intent of the committee? I know you're going to probably have more hearings, I'm assuming. Is it the intent of the committee to have a recommendation maybe going into the next session of some changes, or what would be the next steps?
Well, keep in mind, Frank, I'm just a committee member. I'm not the chairman of the committee. So I do know that we've simply recessed the current hearing.
Oh, okay.
And so we've not adjourned it. So we could fire back up at any time.
At any time.
The committee chairman. I would anticipate that there would be some legislation that would follow this simply because of the interest.
Yeah.
And the need to get it right. I think everyone in the listening audience would hope and pray that we try to get it right.
Yeah.
If we're gonna punish people in this extreme fashion, then we need to get it right, because it could be any one of us that could be subjected to that penalty.
Yeah.
And we'd want to make sure that we were guilty of the offenses charged.
And I appreciate that, and I think the whole reason why it's so important that you're on today is for that very purpose. There's not a lot of information. I know how to do research pretty well. I'm an attorney. I mean, I know how to go find stuff, and I'll be honest with you, it's very difficult to really dig down to find all of the information available. And so the more information, and I really don't know. I mean, I've read both sides, and I would say as a general matter, No, I don't. You certainly don't want to ever put anybody to death that doesn't deserve it. That's just a general matter, right? And I also am a death penalty proponent for the right reasons.
I will say this, that after listening to the hours of testimony, and you mentioned Dr. Phil.
Yeah.
Dr. Phil in his testimony mentioned that he had stopped counting at 47 times that the shaken baby syndrome was mentioned in the record.
Yeah.
So for anyone to say that this was not a shaken baby syndrome case, this was a blunt force trauma case, is simply ignoring the record. It is there, and if you
so let me ask you a question about that. That's a really critical point. So did they deny it based on that it wasn't a shaken baby syndrome case to begin with?
That's exactly. If you'll read the Attorney General's letter, he says this wasn't a shaken baby syndrome case. This was a blunt force head trauma case.
Okay.
And that the autopsy shows that the baby had a mushy back of her skull, and which the record doesn't reflect that. There were multiple contusions on her head and body, which they were not. If you read the record, this was a shaken baby syndrome case. But those that want to stay the course and put this guy to death would say that no, that wasn't really a part of this case. So the idea that scientific knowledge has changed in viewing those injuries is not the case. She was abused and she died, contrary to medical expert testimony saying that she had pneumonia, and that this physical trauma can be explained because of her pneumonia. She was a sickly child for all her 2+ years. Yeah. Her father had taken her to the hospital with a fever. She had a 104-degree temperature. They prescribed codeine and Finnegan that for a 2-year-old that has now been discredited. Has been discredited, and it's not prescribed for children of that age. So there are a lot of expert testimony as to what this baby probably died of, but it wasn't shaken baby syndrome, but for which he was convicted.
Yeah. It's a really sad case, period.
It is a sad case. It is a sad case.
If you look at just how this poor little child, just everything that child went through, even beyond the fact that she died. I mean, it was everything before. It was terrible.
Frank, I will tell you, as a father of 5 and a grandfather of 12, I have blessed to have 12 grandchildren. I will not tolerate child abuse, not in any form or fashion. Yeah. I will not stand in defense of anyone who would abuse a child. And I think our laws need to be very, very clear about that if you abuse a child, you're going to be punished. And so, but likewise, I think if people who have been charged with this very serious crime, there needs to be no other explanation than a physical abuse. And again, we all have had situations where we've had babies in our arms and they pull themselves away and drop to the ground, or they fall out of bed, or they push on us and they flip out of our grasp. There are other explanations than taking and physically abusing a baby. And so I want to be very clear that we're going to punish child abusers. And but I think in this particular case, with the evidence that I've seen in the record that I've reviewed, this man was charged under a body of scientific knowledge that existed in 2003 that has since been discredited. And the symptoms on that child's body, and keep in mind, that's the only way she can testify, is the condition of her body.
Right.
She was in that courtroom. Her condition was in that courtroom. And we need to make sure that we understand what happened to her, and we don't confuse it with something that we now know has been debunked.
As this as the next steps go forward, you know, I'd hope you'd be able to, you know, come back and keep us informed.
Yeah,
you know,
I think it's important, Frank. I mean, what you do is important. It's important that people understand, because their natural reaction is, my gosh, I'm not gonna stand up and support a child abuser who beat his 2-year-old baby to death.
Oh,
And I mean, no normal parent or human being would subscribe to that notion.
Yeah.
But when presented with the facts, then I think we have to be rational in looking at the facts, so we can properly determine guilt or innocence.
Yeah.
And that's why the legislature passed a law says, as we evolve as a society, as a scientific community, our understanding evolves, and let's make sure that we don't continue to punish people as that knowledge has evolved, that they now are viewed, their conviction is viewed in a different light.
Yeah.
And we have an expert that's willing to change his testimony.
Yeah.
And say, I was wrong.
And is that expert? Is that a physician, or is that a? I don't know. I don't think I was
an expert. There was remember the detective that
okay.
who investigated and everything. Yeah. He's the one that testified before us and said he was wrong. This was not a shaken baby syndrome case.
Okay.
He charged it as a shaken baby syndrome case, but he now understands he understands more about what could have happened and what condition the baby was in.
Yeah.
And
Robertson does not have another. That's it, right? He had his appeal. It was denied. Does he have?
I think the Court of Appeals at any time could have a rehearing and consider this case again.
So if they're persuaded by some of this, that's information.
One judge could change their mind and therefore have a 4-3 majority. Right now it's 4-3, not to grant a new trial.
Okay.
And I think that would be the purpose of most people would look, say, well, let's take a look at this case in light of new scientific knowledge.
Yeah. And
have a trial to see if he's guilty or innocent under the new understanding of science.
Well, I think what we'd love to do is, and maybe with your help, get a hold of the detective and the investigator, and maybe have him come on and talk about, you know, his side of it. That might be very helpful, I think, to a lot of people. I mean, bring us, you know, the people that watch and listen to this podcast, they want more information. The more the better. And as we get into the next session, as we're creeping up to the next session, you know how it happens. You start to lose your ability to communicate effectively because of everything else going on.
Exactly.
And so we're kind of on a fast path here, and hopefully we can bring a lot more information to
Well, I would urge you to reach out, and I would urge the listening public to learn more about the case and determine for themselves kind of the merits of the case, but I think those who've looked into it, whether it be the Innocence Project or Dr. Phil, or they have in great depth and detail determined that this man was wronged. He was convicted under a body of scientific knowledge and evidence that existed at the time that has now been debunked.
Well, Dr. Phil was definitely unequivocal in his statement. So thank you so much. This has been really, really helpful. I know our audience is going to really enjoy this, and hopefully we'll get some feedback and maybe have you back again, do a little follow-up, something like that. And until then, get prepared for the January. We just went through a crazy election, so, we got something else crazy coming up. But
exactly.
Thanks again. We really appreciate it.
Thank you, Frank. My pleasure.